Okay, now we've all got our sugar levels up, our caffeine levels up, we'll continue. The next speaker is Eitan Makowski. He's going to talk to you about the cases involving aggravation and disentanglement, both of which have been fecund areas for the Court of Appeal. Eitan practices obviously in personal injuries, principally for plaintiffs but some defendants. His name is an unusual name for us, and just remember this, it's Eitan like a ton of bricks. I'm told that he's a gym junkie and that's about what he can lift, so that's pretty awesome coming from where I sit.
Good morning everyone. I'm going to talk about three cases. One is not so recent and I'm sure it's one with which you're all familiar, and that's a case on aggravation, AG Staff and Philippa. It is very important, and so I thought I'd start with that case, even though it's somewhat old and well known, but it is crucial for aggravation cases. So as I've put in the paper, I'll speak to the paper, but because we might be running a little bit short on time, I'm going to summarise, but if you want some further information or elaboration, the paper is in quite some detail. So the background of Philippa. The plaintiff was successful before Judge Misso with respect to two separate serious injury applications for leave against two former employers, for shortness, Arnold and AG, I'll call them. Judge Misso had held that as each injury materially contributed to the ultimate consequences, leave ought to be granted against both employers. The Court of Appeal found that the trial judge, Judge Misso, wrongly concluded that that approach, the material contribution approach, was sanctioned by Xebec and Jurica, another case I'm sure you're all aware of from 2006, and that Judge Misso thought that he was not obliged to follow the well-known principles of Makowski and Gilletti. The Court of Appeal allowed both appeals and remitted the proceedings back to the County Court for rehearing. Brief facts I have. Mr. Philippa, a fitter, turner and welder, hurt himself in August of 2003. July 2004, persisting symptoms, right shoulder injury, he underwent surgery. Mr. Philippa was then able to return to work between 2004 and 2006 with a number of different employers, more or less unrestricted. Commenced with the second employer, AG, 16 January 2006, full-time, heavy work, hurt himself there in July 2006. What's the correct approach according to the Court of Appeal in those circumstances? It was common ground between the appellant and respondent that Mr. Philippa had suffered two compensable injuries on or after 20 October 1999. It's not liking my approach. The Court of Appeal held that purposes of Section 134AB of the Act, an aggravating injury must itself qualify as a serious injury. Justice, Acting Justice of Appeal Kairu, for shortness I'll just call Justice Kairu, set out the correct approach that should have been taken by the trial judge. What was that? Correct approach. First, His Honour should have identified each injury. 2, delineate the impairment consequences of each injury separately. 3rd, in the case of the AG injury, which was the aggravation of the first injury, the Arnold injury, His Honour should have determined whether the injury qualified as a serious injury. And I think someone's going to try and work out what that noise is. I apologise for that. So the fourth point was whether that injury qualified as a serious injury. And then fourth, in determining whether the worker had discharged the onus of establishing the AG injury, being a serious injury in and of itself, there was a comparison that was required. That comparison had to look at what the worker's condition was before the AG injury and after, and should have made an assessment of the additional impairment. Finally, as the two injuries arose from separate incidents, they could not be accumulated. The AG injury had to satisfy the requirements of serious injury under the Act, the narrative test, in its own right, rather than in combination. There was an attempt by senior counsel for the worker to rely upon Altona bus lines in Lococo, which I refer to in the paper just as Lococo. The argument that was sought to be made was that because the first injury, the Arnold injury, rendered the worker's shoulder unstable and vulnerable to further deterioration from ongoing work, it was a cause of the aggravation consequences arising from the second injury. It was rejected for a number of reasons. One reason was that was not the way the case was conducted at trial, which that fact ought to be borne in mind, the approach at first instance. And secondly, by no means was it clear, according to the Court of Appeal, that the evidence supported such a submission. And I've got a quotation there, but without relevant evidence, for example, showing that there would be such a vulnerability to further exacerbation, it's likely that a Lococo argument would not be successful. That's Philippovitz. Moving on to the next topic, which I've entitled Disentanglement, which we all know what that means. The law doesn't allow accumulation of physical and psychological. There was a case quite recently, July 2013, called Meadows and Lichmore, to which I'll now turn. Maxwell was acting Chief Justice. I'll refer to him for shortness as President Maxwell, who delivered the leading judgment in Meadows. Justice Robson Dixon agreed. This case was about a worker who relied upon a permanent impairment or loss of a body function, left elbow. So the application was for physical only. However, it was clear from the medical material that the worker had developed a pain syndrome, otherwise referred to as a functional overlay. Thus, the Court of Appeal said the starting point, where the injury is work-related, of course, is 134 AB 38H of the Act. The Court, in assessing the pain and suffering consequences of an injury, must exclude the psychological or psychiatric consequences of that injury. It follows that to establish a serious injury, the applicant or the worker must satisfy the court on the balance of probabilities, that, and I've bolded, the organically based pain and suffering consequences satisfy the statutory test of being more than significant or marked and at least very considerable. So the plaintiff was indeed unsuccessful in the county court because despite the trial judge accepting that the pain and suffering consequences did reach that threshold, at least very considerable test, Judge O'Neill was not satisfied that those consequences had an organic basis. So on appeal, the worker essentially argued that Judge O'Neill applied the wrong legal test. There were two other planks or arguments made, but the main one was that's the wrong test. The Court of Appeal dismissed the appeal and set out what the correct legal test is in situations where there are physical and psychological consequences. The argument went like this. The appellant said that it was wrong for the trial judge, Judge O'Neill, to require Mrs. Meadows to show that the physical component of the pain and suffering was the prominent part, and that all that her condition was substantially physically based, or the pain and disability she claimed had substantially an organic basis. I might have to keep raising my voice so that I drown out that other voice.
It's appropriate that we're talking about aggravation.
Paragraph 18, President Maxwell acknowledged as follows. It is of course correct that the statutory test, that is the Act, is not concerned and doesn't talk about whether the pain and suffering consequences are substantially physically based or have substantially an organic basis. There's no terminology like that. But President Maxwell said that it was a conventional and accepted approach in cases where pain had both pain and physical and psychological causes for the parties and the judge to address questions formulated in these terms. And I think we're all familiar with that approach. It would appear that President Maxwell was confirming a previous decision of Jaya Talaki and Toyota Motor Corporation from 2008. In that case, Justice Neve and Pagoni agreed that it is not invariably the case that disentangling must occur in each and every pain and suffering case involving both physical and psychological causes. Ashley said in that case, in some instances disentangling might be a useful methodology in resolving the question, but it may also be the case that in some instances doctors will be able to offer opinions of substance, not mere form, which will assist in disentangling physically and psychologically based pain and suffering. But it would be simply wrong to think that Stamboulakis, that well-known Court of Appeal case, commands such an approach, failing which a plaintiff cannot succeed. And I'll just refer to the case, it's not in the paper, of Xebec. Justice Redlich talks about an ability of a plaintiff being able to satisfy a burden of serious injury, even if there are psychological consequences, if it can be demonstrated that in any event the physical side would constitute a serious injury in any event. So President Maxwell, back to the case of Meadows, accepted the respondent's submission that serious injury applications of that kind in Meadows are approached in the following two-step way. Ask yourself whether there is a substantial organic basis for the pain and suffering consequences. If yes, and of course you meet the relevant serious injury statutory criterion, then the worker will succeed, and I've bolded, without the need for any disentangling of the physical contributions to the pain and suffering from the psychological contributions. Of course, if the answer is in the negative to that first question, then the worker will bear the onus of showing that the pain and suffering consequences are attributable to the physical injury and that they meet out the statutory test, and that will involve separating out or stripping away of the physical and psychological contributions. So finally, President Maxwell held, in my opinion, to approach the serious injury question in this way involves no area of law, and repeats, this is developed as a rule of practice or convenience. There's no new involvement of principle that stands in place or in addition to the statutory requirement. Rather, the approach, in His Honour's view, provides a shortcut to the benefit of a worker, where it can be seen on the materials that the consequences are substantially or mainly or predominantly referable to an organic cause. And so President Maxwell concludes that the Meadows case illustrates that where disentangling does become necessary, it's the state of the medical evidence that will largely determine whether it can be done. And careful reading and analysis of practitioners' medical evidence will be required. President Maxwell refers to Judge O'Neill being an experienced judge who said in his reasons, where at least some of the medical evidence suggests a significant psychological component, the evidence relied upon by the worker will need to be in a condition which will enable the court to clearly identify whether and to what extent the pain and disability has an organic basis or physical basis. Unless the evidence enables that distinction to be made, it will be difficult for a worker to establish on balance that the physical injury counts for the pain and suffering consequences which satisfy the relevant serious injury test. That's dealing with disentanglement from July, and in more recent times, September of this year, is a Court of Appeal case, again leading judgment of President Maxwell in the case of Xebec. Transport Accident Commission was the appellant and Mr Xebec was the respondent. There was an appeal from a decision of Judge Sucardo, where His Honour, of course, gave leave to Mr Xebec. what's Mr Xebec about? Mr Xebec was injured in a motor vehicle accident in March 2008. He was then 70 years of age, sought leave under the relevant gateway of the Transport Accident Act, section 93. In what way did he bring his application? Fresh injuries to his neck and right shoulder, or new injuries to those areas, and aggravation to his lower back. Against this background, I've set out a number of complicating aspects, if I can call them complicating. First up point, there was a pre-accident condition, quite a significant pre-accident condition, where Mr Xebec in 1971 was involved in a car accident, hurt his wrist and lower back, had wrist surgery shortly after, but in 1990 had a laminectomy. Under cross-examination, Mr Xebec confirmed that the injuries from 1971, that first motor vehicle accident, had prevented him from ever working again. He hadn't worked from 1971. Next complicating factor, intervening accident. Mr Xebec was involved in another motor vehicle accident in August of 2010 after the 2008 subject incident. In that one, Mr Xebec was in a van, he was hit from behind. The effect of this accident had to be properly assessed on the medical evidence. A further complicating factor, Mr Xebec at first instance was found to be an unreliable witness. Next, disentanglement issues. Mr Xebec was required to disentangle, according to the Court of Appeal, any psychologically driven pain and suffering consequences in the context of there being evidence about distinct psychological symptoms following the 2008 car accident. And a further point was the controversy as to whether or not the spine is one body function. And so President Maxwell in Xebec reviews the long-standing proposition that the spine is to be treated as one body function. And I'll come back to that after we go through some of these complicating factors. First complicating factor, as I say, was the pre-accident condition. The injured plaintiff, Mr Xebec, went to his GP, Dr Delane, about a month before that March 2008 accident. In that exam, and as we all know, it's important to look at GP clinical notes in particular. In that examination, the GP arranged for a CT of Mr Xebec's lumbosacral spine. Why? There was minimal flexion of the spine at that time, that is, shortly before the subject accident, and there were sciatic symptoms and signs. President Maxwell observes, the evidence of that presentation a month before the accident was of critical importance in my view. It showed that shortly before the accident, Mr Xebec had been having both lower back pain and significant sciatic nerve pain in his right leg. Towards the end of the Court of Appeal judgment, President Maxwell returns to this aspect and finds that on the evidence, therefore, the condition of Mr Xebec's back after the accident was essentially the same as it had been before. That is, stable but involving periodic exacerbations. President Maxwell was unable, therefore, to discern any basis for finding that there had been an aggravation of the lower back injury or worsening of the symptoms which Mr Xebec had been complaining immediately before the March 2008 accident. The next complicating factor, the effect of that intervening 2010 van vehicle accident. First, Mr Xebec failed to tell a number of medical practitioners about it. President Maxwell noted that it must be inferred that Mr Xebec did not inform Mr Dooley or Mr Brearley of that accident, and there was a marked contrast between the accounts that Mr Xebec was giving about his current conditioning to those doctors, and so it would appear that that aspect impacted upon the Court of Appeal's assessment of Mr Xebec's reliability, as well as infecting the weight to be attached to medical reports, which is another important aspect of that decision. Turning to the reliability, however, it wasn't as if Judge Succato found Mr Xebec to be reliable. But after having found, that is, Judge Succato having found that he wasn't reliable, he nevertheless said in his judgment, which is pointed out by President Maxwell, that having regard to what appears to be reliable evidence given by the plaintiff in his 2 affidavits, but unreliable evidence during cross-examination and on occasions and statements made in the course of medical examinations, Judge Zaccato said, "I'm not persuaded that the plaintiff is a dishonest witness." President Maxwell seized on this finding and agreed with the TAC's submission that when Judge Zaccato made an unambiguous finding about reliability, or the lack thereof, as to Mr Xebec's credibility, it was inconsistent and really wrong for Judge Zaccato to have relied on those 2 affidavits. And therefore, President Maxwell explains the ramifications of that. The adverse credit findings against Mr Xebec cast serious doubt on the reliability of the medical evidence. Plainly enough, each medical opinion depended to a great extent on the history given by Mr Xebec. Consequently, the finding that he'd exaggerated his accounts to doctors greatly reduced the weight to be attached to the resultant reports. Conversely, the finding lent support to those reports which were describing Mr Xebec as displaying abnormal illness behaviour or functional overlay, and his active resistance to an examination for range of motion. Before I come to that abnormal illness aspect, an important factor in the case was that Mr Xebec's son was cross-examined and was found to be a witness of truth. In that context, the plaintiff himself having been found to be unreliable and his son being reliable, President Maxwell notes, in the result, the evidence of Mr Xebec's son was pivotal. It was the only evidence independent of the plaintiff which could be relied on as describing accurately the restrictions from which Mr Xebec suffered both before and after the subject 2008 motor vehicle accident. And so I've just put, it's important for both plaintiff and defendant practitioners to carefully assess any discrepancies between what a client or a claimant says about the effects when compared to any corroborative lay evidence. Next was the psychological overlay. If that wasn't enough, Mr Xebec had to disentangle, even though at first instance there was a claim for psychiatric but it wasn't pressed at the hearing. President Maxwell observed that his sworn evidence made clear, nevertheless, that the physical injury had had significant psychological consequences. To the extent that those were contributing to his experience of pain, as I've discussed from Meadows, and his sense of being disabled, they had to be excluded or stripped away or separated out. Mr Xebec spoke of, in his affidavit, long-term mental or long-term behavioural disturbance or disorder, probably not his words, including anxiety, depression and post-traumatic stress disorders that affects many aspects of my life and interaction with others. There was also evidence of the plaintiff's son that Mr Xebec's psychological issues were a direct contributor of his inability to undertake some of the activities of daily life. And there was uncontroverted medical evidence of mental disturbance during the years 2008 to 2010. Overall, what did President Maxwell say? It was clear, therefore, that the psychological impact of the physical injuries was significant and pervasive. On his own evidence and that of others, the 2008 accident had a serious adverse effect on his state of mind, which in turn contributed materially to his experience of pain and suffering. So President Maxwell notes there was no short, simple way of separating out the psychological. And in bold, I've got the fact that necessary disentangling was not done and was probably not capable of being done in this case, given the state of the evidence, was in and of itself another reason why it was not open to conclude that the organically based consequences satisfied the narrative test as Judge Zaccato had held. Now turning to the question of whether or not the spine is one body function. That includes, of course, lumbar, thoracic and cervical. In this case, the TAC sought to submit that Judge Zaccato had erred in treating Mr Xebec's neck and lower back as a single body function. President Maxwell was not persuaded that the many decisions of quite a number of judges at first instance who had held that spine as one body function ought to be overturned. And I've got quite a big chunk from the judgment, but I'll do my best to summarise it. But President Maxwell just thought too late, basically. He notes, President Maxwell, that it's an important question, but for reasons best known to itself, that is the TAC, it had not until now sought an appellate ruling on the question. Over the years, the TAC had persisted with its separate functions argument without success in a number of first instance proceedings before it ultimately conceded the point in 2012 in a judgment of Judge McNamara, and I've got the citation there, Comerford. So the President says, in my view, it would work a great unfairness at this stage in 2013 if the Court of Appeal were to uphold the present challenge, even if it did otherwise have merit. As to the merits, it's of significance that the view now challenge has been arrived at by a number of quite substantially experienced county court judges, and President Maxwell says that those county court judges' reasoning is clear and cogent, so if there's going to be a change now, it will have to be made by Parliament. So I think it's safe to say that it is one body function as matters presently stand. There was also in Xebec talk about the conduct of hearing and serious injury applications in general, because it was a protracted dispute in the county court. President Maxwell starts by echoing those well-known criticisms of Justice Brooking in Makowski, where Justice Brooking then said, "I doubt very much whether Parliament had the present foolish, wasteful and inconvenient system in mind when it enacted Section 93 of the Transport Accident Act." Why did President Maxwell seize on that? There was extended cross-examination of Mr Xebec by counsel for the TAC over a number of days. Judge Succato from time to time would urge the defendant's counsel to be a bit more efficient. However, President Maxwell considered that, as things stand, the conduct of the case on behalf of the defendant could not be legitimately criticised. But he did, that is, President Maxwell did turn his mind to a policy question and asked whether the current system is a satisfactory way of differentiating between those who can and can't sue. Despite the best efforts of judges of the county court and of the Court of Appeal, litigation, serious injury litigation, places an ever heavier burden on the judicial resources of this state. At the same time, there are reasons to doubt whether it is possible to fulfil the requirement of the rule of law that like cases be treated alike, given the imprecision of the narrative test, the intrinsic difficulty of assessing and comparing degrees of pain and suffering, and, in His Honour's view, the near impossibility of separating out psychological from organic causes of pain and disability. Food for thought. I turn to now some lessons or reminders and some further food for thought, bearing in mind the cases which Stephen and I have taken you to. First stop point, beware of aggravation cases. Each injury must be assessed separately in terms of the impairment consequences. Next, as I've said, scrutinise the entire medical record, in particular general practitioner notes, and endeavour to draw a picture of the effects of any multiple contributors on any claimed injuries and consequences. It can be painstaking at times. Medico-legal experts, they need to be provided with a full history and careful review of their reports when they do come in is required well prior to the date for hearing. Any corroborative lay witness affidavits should be compared against what the plaintiff says with respect to the consequences of any injury. For cases with hallmarks of abnormal illness behaviour, plaintiff practitioners will need to make efforts at separating out such consequences and procure evidence to do so. For example, ask the right questions of medical practitioners. Of course, unless the first step that I spoke about, and that's outlined in Meadows, is answered in the affirmative. Similarly, defendant practitioners need to carefully assess to what, if any extent, it considers pain and suffering consequences are in part attributable to any psychological condition over and above a physical injury. And it seems that cross-examination of a plaintiff will continue to be of utmost importance in serious injury applications, and lay witness lay witnesses may also be cross-examined. Just two quick things, because we're almost at 9. I'll just refer you to another decision. The Court of Appeal has been quite busy. 12th of September 2013, FOCAS, F-O-K-A-S, and Staff Australia talks about disentanglement and also looks at Ansett and Taylor and the significance of an admission under 104B of the Act. And we all know about the case of Kochak. The High Court has now heard the appeal, 16 August 2013. You can read the transcript if you dare. You'll remember that that case involved a number of issues, but what is the binding nature of medical panel opinion? Was the Court of Appeal right in overturning Pope and Walker? And as well as the question of adequacy of reasons. The High Court reserved its decision. We await the judgment of the High Court. Thank you.
Thanks very much, Eitan. We've got 5 minutes. I know everybody's anxious to go, but if anyone has any questions, I'm sure we'll do our best to answer them. Yes?
Is there any indication when the High Court's likely to deliver judgment in the Kochak case?
No.
Any other questions? All right. Thank you very much. Thank you to both our speakers for informative and very current issues and the way in which you discussed them. Could you please join me in thanking our speakers and be sure to watch the Greens website for upcoming speeches and talks. Thank you very much.